Yes.
Recording.
I would like to begin by reading out a statement. The hearing on this application is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the appeal bench instructions. We are here for a hearing in the matter of CA-011 before Chief Justice Zaki Azmi, Justice Roger Giles, and Justice Robert French. The appellant is represented by Abdul Hakim bin Herz advocates and legal consultants. Lead counsel is Mashoud Iqbal. The defendants are represented by Al Tamimi and Company. Lead counsel is Patrick Dillon Malone.
Okay, Mr. Malone and the other party is, I didn't get the name just now. Who's appearing for the appellant? Hello?
That's Mr. Iqbal.
Who's appearing for the appellant? Are you appealing for the appellant? I thought you are you appealing for the
respondent, Chief Justice. It's Mr. Iqbal is for the appellant. I can't. He was here. He was here. I don't see his image at the moment.
Good morning.
Yes, Mr. Iqbal.
Good morning, my lord. Can my lord see me?
Yeah, I can see you now. Okay, I can see you now. I think that. So you know, we were the Justice Roger Giles and Justice French and I were discussing this, and we felt that there might be a easy way to a shortcut to disposal of this matter. For that purpose, I'd like to invite Justice Roger Giles to say something. Yeah. Roger, I'll leave it to you.
Mr. Iqbal and Mr. Dillon Malone, can I just check some facts to begin with? Am I right that the timing went like this? That the matter was set down, that on early in July, the matter was set down for hearing with a hearing date of the 13th of August. Step one. Step two, the three applications that we're concerned with were filed on the 22nd of July. Step three, that on the 4th of August, the court wrote to the parties saying that the hearing that had been fixed for the 13th of August was vacated, and that the court wrote on the 4th of August to say that. And the hearing, the applications took place at some time after the 13th of August. Have I got that timeline right?
My lord, more or less, yes. My understanding is very slight variations that the hearing was listed on 11th of August 2020. The three applications were filed on 26th of July 2020. But that is simply the fine-tuning. Otherwise, I am in agreement with your lordship.
Yes. Thank you. I think my recollection was wrong about the 13th, and no doubt it was the 11th. And it doesn't much matter whether the few days about the filing. Mr. Dillon Malone, is that in a...
I concur with that. Yes.
Okay. What that means, and what did occur to us might be significant, is that when the applications were being heard, there was no pending hearing. The hearing had been vacated. And I think, though, again, I ask for your confirmation or otherwise, that it was vacated on the court's own motion. Is that right?
That is my understanding, your lordship.
I think there is a sequence of correspondence, and if this is going to be significant for the court's ruling, I'd refer to it from page 717 of the bundle. There's a sequence of short, it's not a long sequence.
Can you summarize it for me, please?
Yes. I think that the inevitability of the court vacating the hearing was apparent to everybody, and that's apparent in the correspondence. And on the 4th of August, the registry wrote to the parties to say that the hearing had been vacated and that they were requested to provide the registry with their mutual availability for the relisting of the hearing. So I'm not sure whether that means that no hearing was pending. It was still the case, as I understand, that the Part 8, the procedure, the hearing under the Part 8 procedure was still pending in the sense that it was going to be relisted at the time that these applications were determined.
But no date had been fixed.
No date had been fixed. The date had been vacated because you'll see from that sequence of correspondence to going from 717 to 723 that there was no reality in the hearing going ahead in those circumstances.
Thank you. Well, what seemed to us where this seemed to us might be important was this perhaps is something really addressed to you, Mr. Dillon Malone, is that the judge's reasoning was essentially these applications were brought too late, full stop. Whereas one must balance against that the prejudice if by bringing the applications too late, for example, a hearing has to be vacated. That could provide a reason for saying these were too late, therefore I will not allow the applications. But that wasn't the case at all. By the time of the hearing, there was no pending hearing, there was no state.
I don't believe that's the case, Justice Giles. The applications were filed on the 26th of July, out of the blue. That was 11 days before the hearing date, 11 working days, I think, before the hearing date, and about 5 days before the skeletons were due to be filed for the hearing. And it was as a direct consequence of the filing of these applications that the hearing scheduled for the 11th of August had to be vacated.
Yes, and I'm not saying anything to the contrary. What I am putting to you is that nonetheless, when the judge heard the applications, there was no pending hearing in the sense of a fixed date, and that would seem to me at least to be something that was very relevant to the exercise of his discretion whether or not to allow the applications. And that the problem that I see and would invite your response to is that when he reasoned these applications were brought too late and caused the fixed hearing date to be vacated, that left out of account the significant consideration, all right, but nonetheless, there is no longer a hearing date fixed. Therefore, what in the interest of justice should I allow, given that there is now no pending hearing date? That to me at least is a difficulty, and I'd appreciate your response to it.
Well, it may be a factor that would be taken into account, and no doubt was taken into account by the judge below. But the fact that a hearing date had been vacated, the context in which the judge made his ruling, and it's in his reasons, included the fact that these applications had been brought so late that they did derail the inevitably. And it was the case that he was making these decisions in a case of a Part 8 procedure, a streamlined procedure to which he gave emphasis. And in that context, it was, as a matter of case management, having reviewed the evidence that was proposed to be brought in. Admittedly, it wasn't critical, the nature of that evidence, but nonetheless, the substantial overlap in the evidence behind the counterclaim and the fact that no injustice will be done in the Part A procedure was something which he carefully took into account. And therefore, whether or not the actual date had been relisted or not, in my respectful submission, is not a critical factor, not a determinative factor in this court's review of his case management decisions.
Where did the judge take into account the fact that there was no longer a hearing date and therefore there was time, notwithstanding there might have been some earlier lateness, for matters to be put into proper order for a proper hearing?
I think I'll just find in the judgment, if I may. And there are a few references. First of all, at the beginning, well, to the fact that the hearing had to be vacated. Paragraph 7 on page 34 of the bundle reiterates, as already had been mentioned in the opening, that the applications came very late and they caused the hearing of the claim to be vacated. And then at least once following, I'll find it now. Paragraph 24 on page 39 of the bundle. To the extent that the defendant genuinely struggled to make the evidence application, as she says is the case, in my view, her counsel should have informed her opponent and this court of the same, and should certainly not have proceeded to participate in listing a hearing which it was known to them would likely need to be vacated.
Yes, isn't that the problem rather than the solution?
I don't believe that it is. I think that the judge below was fully conscious that a Part A proceeding was in train, and it was clearly in that context that he, having managed the case and having considered everything, ruled that these materials would not, the exclusion of this evidence for the purposes of the Part 8 hearing, the refusal to allow the counterclaim to be filed in the context of that pending Part 8 hearing, and obviously the transfer application, were not, as a matter of justice, matters that would prejudice the parties, would prejudice the appellant in the streamlined procedure on the issues that were to be determined in the Part 8 claim. And I think that the fixing, I understand what you're saying, but I think it would not be fair and would be not consistent with this court's review of the proper review of the decision below, to simply say that there was no hearing actually fixed on the date that he determined the applications, and that for that reason he ought to have that the consideration of that factor is in itself, as a matter of law, a ground of appeal which should succeed. Because in my respectful submission, if and to the extent that he did not take account of that, and I say he did take account of it, because it's clear that from the context that he was making it in the context of a pending Part 8 proceeding, but if and to the extent that he didn't, in terms, address it, I believe it is clear from the judgment as a whole that the fact of the vacation and the fact of a relisting was in the judge's mind. And it was not
just following on your reference to paragraph 24, and I think we probably need to read 25 as the culmination of it, and you referred to the judge's concern for the streamlined procedure.
Yes, indeed.
Now that concern from paragraph 25 seemed to have been a factor in refusing the evidence, what's called the evidence application. Wasn't it necessary to consider the transfer application first? Because if that succeeded, then the streamlined procedure no longer applied.
Yes, well, I would like to address you on the transfer application, of course, and I'm happy to do so now. But there is, in my respectful submission, the judge's reasoning and his conclusion on the transfer application was entirely correct. That the circumstance in which the appellant's arguments that it had to make an application just prior to the Part 8 procedure hearing are not sustainable. And I'll be looking forward to taking the court to those arguments and to my responses. But it really, the position is that there was going to be a consideration following the Part 8 procedure hearing of whether or not Part 7 proceedings should be directed. And that's still the case. And when it comes back to the court below, you will have seen that Justice Cook has indicated in his judgment in the other case that he will be taking seisin of the case management of this and the related proceedings. And I think it may be that one could have taken the applications in a different order, but in the reasoning that was adopted, and the judge below was not wrong about the counterclaim, because what was being applied for in the transfer, on the transfer application, because what was being applied for in the transfer application was the very issue that was about to be, one of the very issues that was about to be determined on the hearing that was pending and that was imminent. And there is a suggestion in the appellant's skeleton that in some way they were deprived of a hearing on that. But of course, that's not the case. What they applied for in terms was the actual order to transfer. And that was correctly refused in my respectful submission, because effectively it prejudged what was already pending before the court. Nobody's been deprived of an adjudication on that issue that is pending in the Part 8 procedure.
Aren't we looking at the judge's the result for the judge and his reasons for on the transfer application? That's what
yes,
the field of.
Yes, of course. But I would like to.
What are his reasons? To me, it seems it's very much the application was thought of earlier, was not brought, it was brought too late, therefore I refuse it. Is it any more sophisticated than that? I don't mean that in a disrespectful sense, but is that a summation of it?
Well, that's certainly the thrust of what is said, and I don't disagree with that. But at the same time, it's clear that the judge had in mind the streamlined procedure and the context that was on foot, which was that these very issues were about to be determined in a hearing that was absolutely imminent.
Where does he refer to that?
Again, those references to the streamlined procedure at the very end of the judgment. There is also
I'm not too sure that I understand you. Can I say what I think I understand you're saying?
Yes.
Are you saying that because there was going to be a trial, it was unnecessary for some reason or other to decide the transfer application? Is that really the gist of what you're saying?
No, absolutely not. Of course, the judge had to
understand. Would you mind telling me again?
Of course not, Justice Giles. He had to consider the application, and in my respectful submission, he did. He took account of the context in which it was made, the impact it would have, and he relied upon the lateness of the application as his express ground, and that was within the discretion of the judge as a matter of case management.
Okay. Now, wasn't it a relevant consideration for the judge to ask, is it in fact a case which should be transferred to a Part 7 procedure?
Well, he did not. He clearly did not do that in his judgment, and
But isn't that a bit of a problem? Because surely that's one of the vital factors.
Yes. Well, I say not, because those were the very issues were the issues that were going to be determined in the Part 8 procedure application that was pending. So there was no need for him to go there. He says at paragraph, I think it's where he says, I'll find the right paragraph, excuse me. Paragraph 11, in relation to the evidence, but this is under the section late application. So it's at the conclusion of his introductory paragraphs, having identified the causes of delay and analysed the position advanced by the appellant as on the causes of delay. He then says, with that said, I do not think that a detailed investigation into evidence of the defendant has submission is required. For me, the applications each fail at earlier junctures. And therefore, yes, it is express in that the judge is saying, for the purposes of the transfer application, that he's not going to adjudicate on, and nor was it necessary for him to adjudicate on whether there were conflicts of fact of such a character that would require him to transfer immediately. And the reason being that that very issue was about to be determined in the Part 8 procedure. And I remind that on that aspect, of course, we have not made any submissions on that. That issue of whether there should be a Part 8 or Part 7 procedure, that has not been argued below at all. Of course, there are submissions now made before you by my friend on the appeal, but they have not been the subject of any or any submissions below or any determination below. That is the issue that on the part, one of the issues which was pending imminently on the Part 8 procedure. So how could the judge have erred when he knew that that was the context? In my respectful submission, it was well within the margin of discretion for him in managing that Part 8 proceeding. And he had in mind the overriding objective and the streamlined procedure of the Part 8 procedure.
Yes, I understand. Well, thank you. I did want to raise with you what I thought, and I have to say, still think is a difficulty for your side, Mr. Dillon-Malone. I don't know if my brethren wish to intervene or...
Perhaps we should hear what Mr. Iqbal has to say on the same issues that Mr. Patrick has just responded to your questions, Judge. Shall we hear what Iqbal has to say?
Yes, certainly.
Well, indeed, first of all, good morning / good afternoon, depending on wherever all the judges and participants happen to be. My submission is that the point that my Lord Justice Giles has raised, I have attempted to raise, I wouldn't say exactly the same point, but albeit a slightly similar point in my skeleton arguments from paragraphs 81 onwards. In summary, what I say, well, I think I would first wait for your lordships to get to the skeleton arguments. In the paper bundle, top bottom left-hand corner, page 867.
Yep.
Now, what I submit is that let's suppose for a moment that the hearing remained intact on 11th of August and it would have been before Judge Al-Sualehi. On that very day, he would have had 3 applications in front of him: evidence transfer and the counterclaim applications. Had it happened that on 11th of August he had to decide these applications, and yet at the same time he would have had to decide the hearing on Part 8 claim, then the point that the 3 applications were made at a late stage, and if granted, they would have had the effect of derailing the trial or vacating the trial to another day. That was not the point, because the hearing had already been vacated. So the fact that the overriding objectives, which requires the court to determine cases proportionately within a reasonable period of time, it did not matter, because on 11th there was no hearing anyway. So my submission is that the 3 applications ought to have been heard and determined on their merits, starting first of all with the transfer application. Because if the transfer application, whose only question of merit would have been under Part 8, is there a substantial dispute of fact? Yes or no? If the judge, having read the documents, particularly, more importantly, the pleadings, the particulars of claim, the defense, and the reply to the defense, and more importantly, if the witness statements were to be added on top of that, my respectful submission is that the straightforward answer would have been yes, there is a substantial dispute of fact, and mainly on the basis that the defendant's case is that in the agreements in question, there were misrepresentations. Now, on the alternative, let's say if the judge said that although, yes, the merits of this application may be strong, But because of this application, the trial is going to, or the hearing is going to be vacated. Well, if that had been the case, that could have been addressed by way of an appropriate order for costs, rather than completely shutting a door to the defendants for their conversion application, the transfer application. So again, I would seek to confine myself to this very point that my Lord Justice Giles has raised at this point, unless I can give any further assistance.
Mr. Iqbal, did you make an application to move the matter from Part 8 to Part 7? Was there a formal application?
My Lord, yes, dated 26th of July.
26th of July. Yeah, but there is, yes, 6th of July. What was it about? The application, where is it in the, was a formal application?
My Lord, yes, it was a formal application. I can take your Lordship through to that formal application in the bundle. If I can just borrow a few seconds, please. My Lord, that is in section G of the bundle, and I will just in a moment take your Lordship through to that. That is page number...
A page, just a page.
Just one second, my Lord.
I'm sorry to interrupt. This morning, Chief Justice, I forwarded by email this morning a single page index to the registry. It was a select index, which may be helpful to the court.
Oh, I see. Yeah, I saw the email.
My Lord, in the electronic bundle, it's page number 97.
97.
And my Lords who have the paper bundle, it's page number 93, bottom right-hand corner.
97. Okay, nice. Transfer of application dated 22nd of July.
My Lord, yes, on the top right-hand corner, it does say 26th of July, 2020.
The case was filed on?
12th of March, 2020, my Lord.
Oh, 97, yeah, good, yeah. 97. So there was a formal application to transfer.
My Lord, yes.
It's not a transfer. 97 is...
Okay. My Lord, 97 is the electronic page numbering, the PDF page numbering. And if we look at the internal page numbering in the bundle, bottom right hand is 93. Perhaps Mr. Dylan Malone.
93, okay. 93, yes, 93. Okay, sorry. 93. Party filing appear, okay. Application notice, sunset, defendant. Application to with notice that the present application filed by defendant be allowed and claim filed when the Part 8 be changed to and be dealt as Part 7 claim. And Part 7 procedure to be accordingly followed. Such further alternative claim as we be. And was there any order there? Of course, there was no order.
My Lord, yes, there was an order that is dated 1st of October by Judge Al-Swalehi dismissing this application along with 2 other applications.
Dismissed.
There were 3 applications filed on 26th of July. Number 1, transfer application, which is Part 7 to Part 8 to Part 7.
Yes.
Number 2, it was the application seeking permission to file counterclaim,
Yes.
also filed on 26th of July. Then there was a third application seeking permission to file additional evidence. All of these three applications were decided. Were dismissed, yes.
Were dismissed.
Exactly. Hence
on
this appeal.
On the ground that you filed in late.
That's one of the grounds, one of the reasons, lateness.
But the respondent is saying that you're not appealing on this particular application. You're on record. You're already appealing on two matters, but not on the transfer to Part 7. That's what in his submission. Didn't you? Yeah. You mentioned that, no?
No, that's not my
understanding. You mentioned that there was only appeal on only two grounds.
No. As
yes, I think in the skeletal outline, which was dated the 27th of December, at paragraph 3, you said the appeal is limited only to the extent of the evidence application and the transfer application.
Yes, my lord, if I could make a clarification here, I intended that in the course of opening my submissions for appeal, I would immediately take your lordship through to paragraph number 3 of my skeleton arguments, because here I seek to make a little clarification, and that is this: that at the time when I drafted my skeleton arguments, having read Judge Al-Swalehi's decision granting permission to appeal, it was my understanding, which I now understand that was incorrect, was that the grant for permission to appeal was limited only to the transfer application and the evidence application. That was my misunderstanding. Those instructing me have instructed me that alongside the application seeking permission to appeal, another application was made for seeking permission for counterclaim. So by the time Judge Al-Swalehi determined the permission application, he in fact had two simultaneous applications in front of him. One, another counterclaim application, and second, the transfer application. Second, the permission to appeal application. So Judge Al-Swalehi dismissed that second counterclaim application, but he granted permission to appeal. So now I seek to make a clarification in paragraph 3 of my appeal, that this appeal is not limited only to the transfer and evidence application, but it is also against the counterclaim application, and if necessary, to that extent, I would seek leave, to be absolutely cautious and courteous to this court, I would seek leave to amend / rectify / clarify my skeleton arguments. However, to keep things simple, I would remain loyal to my strategy that I would put the transfer application as my flagship point, because in my understanding, in my submissions, if I am successful on the transfer application, then the other two applications, counterclaim and evidence, will become academic, because once transferred to Part 7 procedure, we can then file those applications according to Part 7 procedure.
Is that because of the timing? That is, that the time for filing a counterclaim will only begin to run from the time of transfer to Part 7? Is that what lies behind what you've said? If not, why does not the same situation apply?
My Lord, what we say is that the timing wouldn't offend the strictness of the rules, be the timing, well, first of all, the application for counterclaim has to be dated 26th of July, regardless of the fact that whether the claim is transferred into Part 7 procedure or otherwise. Because let's say, for argument's sake, if, and I'm being absolutely optimistic, if this court transfers this case to Part 7, then I do not need to make a further Part 7 application, because my Part 7 application dated 26th of July 2020, I would use the term be resurrected and put before the court under Part 7 to be dealt with, or alternatively, perhaps this court may wish to decide the counterclaim application of its own in this appeal proceedings. So there remains a possibility that transfer application, if successful, then this court can make a decision on the counterclaim application on merits. If not, then this court can remit the counterclaim matter to the court below, where it has to be dealt with under Part 7 procedure.
I would need to be persuaded that you would be back to square one if you got transferred to a Part 7 procedure.
Yes, because, my Lord, as long as we remain under Part 8, we have to seek permission to file counterclaim.
Yeah.
If we are under Part 7, then it is my understanding we do not need to seek permission to file counterclaim, because we can then file counterclaim as a matter of right, as opposed to discretion of the court.
I think there might be a time limit on that. Can we look at the rules and see what they say?
My Lord, yes, I'll have a just look at the form. My Lord, it's Part 21 of the procedure rules.
Part 21.
Part 21, yes.
Yes.
It's 21.7. A defendant may make, well, once my lords are at Rule 21.7.
Yes.
21.7. A defendant may make a counterclaim against a claimant by filing particulars of the counterclaim. A defendant may make a counterclaim against a claimant without the court's permission if he files it with the defense. The defense and counterclaim should normally from one document with the counterclaim, or from the defense, or at any other point with the court's permission. Well, to that point, because we filed the counterclaim separate to the defense, I would say under 21.82, we would still need permission of the court.
Yes. You still
Yes,
need
well,
permission with the court.
Indeed, yes. Well, I take my earlier point back. Regardless of whether I'm Part 8 or I'm Part 7, I still fall within the court's discretionary hands to seek permission.
Because you didn't file together with your defense.
That's correct, my lord.
File with your defense, you don't need court's permission. But if you don't file with your defense, then you need the court's permission. Okay.
My lord, yes. Yes, that's according to Rule 28. Yeah. My Lord, yes.
So is the end result that you are saying you are appealing against the refusal of leave to file the counterclaim?
My Lord, yes.
Yeah, that seems to be the end result of what you've said.
My Lord, yes, that is indeed correct.
And the problem again lies because you were late in doing what you did, or your client delayed, and the judge was not prepared to accept those reasons and good reasons for your delay. I think that's all, isn't it?
My Lord, yes. What I say is that because there were 3 applications, insofar as the counterclaim application is concerned, your Lordship is correct, and I am in agreement that the delay was one of the biggest factor because of which the learned judge below dismissed the counterclaim application. To that extent,
can you? This is for myself. I want to say, can we hear your justification why the delay should not be the ground, or should be a ground for dismissal of your applications? The delay is because your delay is not very strong reasons. One is she was delivering a baby, or she just delivered a baby, but that was, it seems, 4 months before filing or something like that. And then there was a question of a mother, 85-year-old lady who was not well. Yes. Those are the 2 reasons why she delayed in putting her application. Actually, she's not doing herself. She's instructing solicitors or counsel like you to do so. So what is the, why do you think the judge was wrong in the decision, his decision?
My Lord, just restricting myself to the subjective reasons for the delay. Yes, being 46-year-old, she had given birth to a baby. Secondly, she was looking after 85-year-old mother. Thirdly, because of the worldwide pandemic, there was restriction on movements. And fourthly, that the dispute between the parties goes back to circumstances in 2013, about 7 years ago, when my client had made a payment of 450,000 Emirati dirhams, and the integral part of her defense is that she's not a nominee shareholder. She's a beneficial.
That is not the reason for the delay.
What I submit is
not the delay. Delay only 3: give birth a baby, or looking after mother, and COVID.
My Lord, the reason relating to COVID is that she had to go to a different premises to dig out the documents in relation to the previous agreements with the other party that included the payment of a check.
But as the judge had said, you asked for 2 weeks extension, which was granted to you. Because the judge saying that if you ask for 2 weeks, you would have, or she would have known that that's all the time that she needs to look for the documents.
Yes.
That's why something like that. The judge said that in his judgment.
No. The point is this, that the reason to find the previous documents arose as a result of the reply to defense filed by the claimants. Because in the reply to defense, they simply said that back in 2013, the defendant did not make any payment of £450,000. To counter that point, there was then a need to find the further documents, and that need arose after 12th of May 2020, not earlier than that.
I can't follow, Yes. You filed the defense, there was a reply, and yet it was never transferred to Part 7.
I beg your pardon? I beg your pardon?
There was you filed a defense, there was a reply, and yet it was never transferred to Part 7. It remained as Part 8.
That's right. It remained as Part 8. And the reason
you filed your defense, the reply, and yet you remain as Part 8.
That's correct. Yes, we remained in Part 8. However, what we say, and as I have forcefully said in my skeleton arguments, that we filed the objection on Part 8 procedure as early as 20th of April 2020, the day when we filed the defense. So
is it right that the court, by reference to what was in the defence, could of its own motion under Rule 8.4 have directed that the claim continue as if the claimant had not used Part 8?
I beg your pardon, my lord. The very last word I could not understand.
Yes. I'm referring to Rule 8.4. The court may at any stage order the claim to continue as if the claimant had not used the Part 8 procedure, and if it does so, the court may give any directions it considers appropriate. You filed a defence. There was, in fact, a statement at the beginning of the defence to the Part 8 didn't seem to be the right place to be, but they'd leave it to the court's discretion. Do you accept that the court could have made that decision without any application on your part?
Well, that's indeed my case. We say that we had invoked the court's discretion in paragraph 1 of the defense, and once the discretion is invoked, the court has to exercise it one way or the other. Whichever way the court exercises the discretion, that must come with reasons. If the court had said to us that for X, Y, Z reasons, your objection to Part 8 procedure is not upheld, that would have meant that the court had made a decision under 8.4. Then I would have had no cause of complaint. But what we say is that under 8.4, no decision was made, regardless of the fact that we had invoked the court's jurisdiction as early as 20th of April. Well, as a matter of fact, we wanted to raise that objection even earlier than that, on 25th of March, when we filed the Acknowledgement of Service. Because the form does not or did not give us the option to object Part 8 procedure, so we could not. But had it given us that option, we would have objected it on 25th of March. And had we done that, then certainly under 8.3, the court officer would have taken it to the judge, and the judge would have made a decision under 8.4. But regardless...
Why did you say the form did not provide for your objection?
My lord, yes, because if I may refer to the electronic bundle, page 888, the very last page, just one second. Yes,
It's
888A. I'm grateful, thank you. So, my lord, that is the Acknowledgement of Service form. And if we turn to page number 2 of that form, on the top left-hand corner, you can see the defendant's response. And you can see that is defendants admit this. Well, I'll leave it to the court to read through.
Again, page 888.
88.
I object to the claimant issuing under this procedure.
The fact is, isn't it, that it would have been open to the court, even without an objection on your part, if the court officer looked at the statement of the claim, looks at the defence, and it appears from the defence that there's going to be a substantial dispute, or there's a likelihood of a substantial disputed fact, that could be brought to the judge, and the judge might decide if this is not really a Claim 8 matter, I'll act under 8.4, and it can go into the Part 7 stream. The problem is, it seems to be that this whole appeal is centred around the fact that you made an application. It was all focused on the application for transfer made on the threshold of the hearing date, and then there was all this stuff about lateness came in.
Yes.
You had, as you say, raised an objection, which wasn't regarded as an application, obviously, in the defence that you filed.
Yes, my lord. Yes, my lord, I take it. Well, that's in fact the correct summary what happened. But here's my submission. My submission is this, that in the entire RDC rules, it is only Part 8 in which... Sorry. It is only... I think somebody's microphone is on, so...
My apologies. I apologize for interrupting, but I realized that the document at 88A omits the relevant section by some quirk of printing out. The form of the DIS report does include express box for ticking, and I'm going to get that uploaded now. There's a specific box to tick which says the defendant contends that the Part A procedure should not be used, and then there's a box for reason where you can write in your reason. And of course,
are you speaking? I can't hear. Something is wrong with my system. Something is wrong with my system. Maita.
Can you hear me now?
I can't hear you. I can't hear you.
Yes, Chief Justice. I'll ask the IT department to look into it.
Can the other judges hear me?
Yes, I can hear you. But I should say that Mr. Iqbal has been...
Can you hear me?
...for some time.
I can hear you, my lord.
Mr. Iqbal, if you turn your camera off and then on again, maybe you will be moving. You have been frozen, at least on my screen, for quite a time.
He's no longer frozen on.
Okay, my lord, I have turned on my camera, perhaps.
No,
Did that make the difference?
No, well, on my screen you're still frozen, but I can hear you clearly, so that's all right.
Okay, because I think perhaps Judge French can see me vibrating.
Yes, I can see you moving.
Okay.
If at all it might help Judge Giles, I'm more than happy to log out and log back in.
The important thing is to be able to hear you.
I'm grateful, my lord.
I can't hear the parties. I can't hear. I don't know what's going on.
I think you're back with us, Chief Justice. I can see you and hear you.
Yes.
Okay, I'm back here.
Okay.
Sorry about that. Something went wrong. I had to disconnect and reconnect again.
Okay, my Lord Chief Justice, can you hear me?
Yes, I can, Mr. Iqbal.
Thank you.
I thought Patrick was saying something when he went dead on me.
I'm very grateful. I won't take long. It's just to point out we are endeavoring to upload the how you look at the screen when one is acknowledging service in the DIFC Court of First Instance. There is a box, contrary to the submission of the appellant, and it says that you can tick it to say the defendant contends that the Part A procedure should not be used. And then there's a box in the reasons, and then of course there's the supporting documents. So we're endeavoring to upload that.
It's section
That's
D.
correct.
Patrick, it's section D, isn't it? It's section D. I object to the claimant issuing under this procedure. My reasons for objecting are. That's what you're referring to?
I don't, on the form that I'm looking at, there's no sections as such. They're not listed as sections. But when one is doing it on screen, perhaps there is a C and a D. But there certainly is underneath the defendant's response boxes, and underneath the remedy source, directly underneath that, there's a box for the defendant contends that the Part A procedure should not be used, and the reason. And therefore, that entire submission of the appellant is based on a misapprehension, unfortunately.
Okay. Well, first of all, I will certainly hold my horses until my learned friend uploads that particular form. However, my Lord Chief Justice, the form that my Lord Chief Justice was looking at, that is the English Court's Acknowledgment of Service form. That is N210. That is not. That's not the DIFC court form.
Okay. I beg your pardon.
Yeah, the point I was making that the English N210 does give that provision / right to make an objection expressly, but not the DIFC form. Anyway, I will hold my arguments until my learned friend refers us to that. And with your lordship's leave, because Judge French had made a point which I think is important to address that too, and that point was that regardless of the fact that in the Acknowledgement of Service form there was a section or there wasn't a section, nevertheless, in the defense, we raised an objection, and our argument is that because we had raised the objection, so under 8.3, the court officer should have referred it to the judge, and if it had been referred to the judge, then the judge would have had to decide whether our objection should be upheld or should not be upheld. And
so you are saying it is on the motion of the court itself. You don't have to make an application. That's what you're contending, are you, Mr. Kebab?
Well, first of all, the court has the inherent jurisdiction. It can do on its own motion. That's one. Number two, if we look at 8.17, in 8.17, where the defendant contends that Part A procedure should not be used because there is a substantial dispute of fact, he must state his reasons when he files his Acknowledgement of Service. So what 8.7 says, that the defendant does not need to make an application. He can simply put in a written statement, and if he puts in the written statement, then 8.18 is relevant. When the court receives the Acknowledgement of Service and any written evidence, it will give. So when it says will, it's not discretionary. That's an obligation on the court to give directions as to future management of the case. So what we say is that under 8.17, the defendant had the liberty to object to the Part A procedure by putting in the written reasons. And that's exactly what we did in paragraph 1 of the defense. And the defense itself is corroborated with a statement of truth. When we had done that, then under 8.18, it was for the court to exercise its discretion, and that discretion is under 8.4.
Mr. Iqbal, there seems to be a problem there in that the defence is not the acknowledgement of service. Do we know one way or the other whether an acknowledgement of service filed on by your side included an objection.
My lord, I can take you to the acknowledgement of service first of all. That will give a straight answer. That is at, with apologies, 1 second, I'll just get to that.
Page 45.
I'm most grateful for that. Thank you. My lord, yes, it's the page 45, electronic numbering is 49. That's the acknowledgement of service we have is 25th of March 2020. In the middle we see defendant's response, type of claim part 8, defendant's response. The defendant intends to defend all of his claim. Now, here we say we did not have an option to object to the Part 8 procedure because in the electronic form we did not get the right option. It is for this reason that we refer to page 888B, which is the very last page in the electronic bundle. So coming back to Judge Giles' point.
I'm sorry to interrupt again, members of the court and Mr. Iqbal, but we have now uploaded at 888D the entire form. What happens is when you press Part 8, when you tick Part 8, another box drops down, and that's the one underneath remedy sorted at the very bottom of 888D, and that appears automatically.
Mr. Dillon, I can't. I'd be most grateful if that could be emailed to me because I can only see a PDF copy of the form of the bundle. I can't see any additions to that.
Of course, we'll do that immediately.
Thank you.
You are saying that the court forms has another page following document N. It says master 888C. You say there's another one coming as 888D. Is that what you're saying, Patrick?
That's correct, Chief Justice. It's been uploaded. Perhaps you need to refresh your bundle, but I think it refreshes automatically, as far as I know.
Is this part of the court form?
If you maybe close your section P and then reopen it, perhaps that might help.
But why does it say document end, END, at the end of 888C?
I think if you close section P, Chief Justice, it may, and then reopen it, you should get a fourth document. Or refresh the page.
But it's going to take time to open again.
Sorry. I'm terribly sorry, members of the court. It was something we hadn't realized.
Can't you show in some other form? Is there any other form that you can show?
We can email it to the registry as well.
Email, I can open it faster.
Can we email it to the registry? Email to the registry. Thank you. Perhaps can I ask, do the other members of the court and Mr. Iqbal, can you access that fourth document?
Well, I've helpfully received an email from your offices, Mr. Dillon Malone, and I can see that a form has been emailed to me, And the form that I can see now, it does reflect the defendant contends that the apartheid procedure should not be used. However, I have not seen this form before, and this is in contrast with the form that we can see at 88B, and the contrast is crucial. Now, it has come at a point where I find myself in a blind alley, because the point that the Acknowledgment of Service does not give the option to contest Part 8 procedure, I had put squarely and clearly in my skeleton arguments on 27th of December. And since then, there's been around 3 weeks period of time, and it is only during the course of the hearing that this new form has been brought to my attention. So I am practically and literally stuck.
You say you're prejudiced because the form never came to you at the appropriate time.
My lord, indeed, and that is the reason that quite emphatically in my skeleton argument, that is the first point I have taken in paragraph 54.
But you did mention in your defense that the matter should perhaps be moved to part 7.
My lord, that is indeed correct, yes. Yes, in substance what I say, that in substance we raised it quite unequivocally and expressly. As a result, under 8.3, the court officer should have noted it, and even if he did not note it, because we had raised it under 8.17, therefore under 8.18 the court should have given direction that could have been very well against me. Court could have said that for XYZ reasons the claim should continue under Part 8, but that did not happen. As a result, we say that on 26th of July, or around 26th of July, when we were around 2 weeks short of the trial or the hearing, we had no choice except to make an application to the court that please look at my defense wherein I had raised this objection, and now formally I am making an application. So what we say, we are not the sort of claimant who would either lie hands on hand or continue sleeping until 59th minute of the 11th hour, and just at the doorstep of the court on the morning of the hearing, we come up with something absolutely new that would derail everything. Quite the opposite. Right from the very start, we alerted the court and we expected that our objection would be decided one way or the other. It did not happen. So ultimately, being choiceless, we made the application. That's the factual scenario. Legally, what we say is that Part 8 enjoys a distinct position under the whole of the RDC. There is no other comparator in the whole of the RDC like 8.17, which requires only that submissions objecting a particular procedure is to be made, and then the court will give direction. This is the unique status of RDC 8. So we say that in principle we were not required to make an application. Although we had an option, and we exercised that option when we saw no hope that the court is going to give direction under 8.17, and it is this factor that the learned judge below ought to have appreciated whilst giving his judgment. And I would say, as I did in my skeleton arguments, that the claimant did play a part in misleading the judge when the claimant made a submission that the defendant did not object to the Part 8 procedure, rather left it to the court's discretion. Can I please make a reference to the judgment of the learned judge at paragraph number 33, please? It's the second sentence on paragraph 33. The claimants also submit that the defendant is incorrect to state that she had already objected to the Part 8 procedure, inverted commas begin. The defense as filed, in fact, deferred to the court's discretion under RDC 8.4 as to whether to continue with the Part 8 procedure. What we submit is that the defendant did not refer the judge's attention to 8.17, which makes an explicit reference to the statement. That's in fact the statement of his reasons. So what we say is that as under Part 8, particulars of claim is not mandatory, though optional. Defense is not mandatory, although optional. Similarly, to raise an objection on Part 8, an application notice is not mandatory, though optional. And it is why it's optional? It's because of 8.17. Now, another submission is that, say I make an objection exactly in accordance with 8.17, exactly in accordance with that letter and spirit. Why then should I make an application notice paying certain amount of fee to the registry and going to the expense of that? It's not in the interest of overriding objective. So what Part 8 procedure requires, well, in fact, Part 8 procedure is unique because it's a quick solution to a problem subject to certain qualifications. If somebody abuses that procedure, then the court has the whip in its hands, and that whip can be used under 8.4. And in order for 8.4 to come into action, either the procedure under 8.3 or 8.17 must be followed. And if 8.17 is followed, then 8.18 is triggered. And if it's triggered, then court has to give directions one way or the other. And Judge Al-Swalehi should have referred to this very nature of the rule and should not have criticized the defendants that up until few days away from the hearing, you did nothing, or you chose to do nothing.
Basically, if you read his judgment, your fault is the delay. I mean, he starts off his first paragraph of the judgment. He mentioned 15 days before the scheduled hearing, and the hearing had to be vacated, blah, blah, blah. And that was not the 26th of July, that she primarily applied to the court for permission to file additional evidence. Applications have all come, therefore, very late. And as mentioned above, they have caused the hearing to be vacated. So your fault is the delay.
Yes, my lord, yes, that's obvious from that. But what we say is that, okay, let's say, for example, I put everything to one side. Just for argument's sake, this is what I say. Okay, there is a delay. Number two, there is no hearing because the hearing has been vacated. Now the applications must be decided on their merits. And the merit of the transfer application is just one question. is there substantial dispute of fact? Yes or no? The judge did not give consideration to that question of merit. Now, insofar as the delay is concerned, we experience as a matter of practice that the question of delay and the prejudice to the other party can be offset by a penalty of costs. That could have been one option to the judge, and that was not at all utilized. So what we say, that the delay factor has been blown out of proportion, forgetting everything else. Most importantly, my lord, the merit. Now, I'm absolutely reluctant to go into my skeleton arguments right from the very start, wherein I have demonstrated.
Yeah, Mr. Iqbal, I suggest you pause there for a while and let us listen to Mr. Mr. Dylan Malone on the issues that you have just mentioned. One is basically delay. Delay. The judge gave a very important point on delay. And secondly is your discussion or your submission on the part 8, about filing and what you submitted just now. No hearing vacated and all those things. Can we hear you, Mr. Dylan? Patrick.
Thank you very much, Chief Justice. Yes, I think the best place to start is with the form, if I can take the second point first. It is the case, and in my respectful submission, it was the case at the time that the Acknowledgement of Service was filed on last March, that when you press the box which says Part 8 on the electronic form, which is the only way in which the Acknowledgement of Service is filed, a box drops down, and we can see it on page 888D of the bundle at the very bottom. And you'll see the difference between the previous one that we had uploaded and this one, is that in this one, the Part 8 procedure is ticked. You see type of claim Part 8. And that box then, underneath remedies sought, says the defendant contends that the Part 8 procedure should not be used. And then over the page, it says reason. So one can type in the reason there that there are, for example, conflicts of fact.
Are you saying that the appellant should have seen that box, that 888D should have appeared on his electronic whatever it is?
If they select. Yes, if they selected the Part 8 procedure when they were acknowledging service, and if they ticked that box, the defendant contends that the Part 8 procedure should not be used, then that would have appeared on the printed, issued acknowledgement of service. But when one doesn't tick it, it doesn't appear, obviously, on the issued notice, and nor does the absence of that appear on the notice.
This is a technical or factual dispute by the appellant. He said that he doesn't get that part of the form. He did not receive that part of the form, and he was comparing that to the English form N210, which has that similar box. I don't know why he didn't get it. I don't know.
Yes, but he's simply
maybe the system.
Wrong about that. He's simply wrong about that, Chief Justice. And it is a fact that the Part 8 application process online for the includes an express ticket box for that. One can insert the reasons, and then one can append any documents. And that is the case. It just was not done here. So it is all of the appellate submissions relating to it not being its fault, that it was beyond its control, that it didn't have an opportunity, are based on a misapprehension. And even if that misapprehension were correct, it is nonetheless still the case, of course, that under the express terms, emphatical, unequivocal terms of Rule 817, upon which the appellant relies, it is an obligation, nonetheless, an overriding obligation, that when one is filing one's acknowledgement service and one does object, then you must do so at that time. So even if the appellant were correct and that box didn't exist, but it does, they would still have an obligation to put in their supporting documents upon which they rely, and to object at the time of service by means of an email or otherwise to the registry. And it is simply just incorrect and unsustainable to say that it was beyond its control, or that, as have been said in the skeleton, that they cannot be blamed for a failure of design in the form, because there was no failure of design in the form. And turning to the next issue then, or in terms of that sequence, the submissions of the appellant on the meaning of paragraph 1 of its defense are, again, in our respectful submission, unsustainable, and they really beggar belief, in the sense that, notwithstanding the express terms of the paragraph 1 of the defense, it says, notwithstanding the unsuitability of the Part 8 procedure in this case, in terms expressly defers to the discretion of the court under Rule 8.4. And of course, the court and the party and my client understood very well from that, as is often the case, a hearing of the Part 8 application, or a hearing under the Part 8 procedure, would continue to include the capacity of the court in its discretion to rule on the Part 7 possibility, on having regard to the test in 8.11. And it is not the case, and again is not a submission that this court could accept, that the judge below was under an obligation, while the pleadings were being exchanged in anticipation of the hearing that had been set under the Part 8 procedure, to trigger a decision. It's, of course, was within the discretion of the judge to do that. If the judge had been reviewing matters along the way, as the evidence was filed, perhaps the judge could have, of his own motion, done that. But he didn't. And the parties were preparing. The skeletons were about to be filed. In fact, the skeleton, we actually have a draft skeleton which is substantially complete for that hearing. We were ready to go. The skeleton bundles were being prepared. The hearing bundle was being prepared. And in those circumstances, when the applications were made, it is not the case, as has been suggested, that in some way the judge could have continued with the hearing realistically with those 3 applications before him on that day, because, of course, that ignores the fact that we ought to have had an opportunity in those circumstances to respond to the 3 applications. And so, therefore, it was inevitable that these applications would have to be considered by reference to our own submissions on them as well. And in the event, the suggestion of Mr. Iqbal that everything could have come before the judge on the 11th of August and considered by him at that stage is not a realistic proposition, and one that the court below quite validly and sensibly avoided. Clearly, you have to hear both parties on applications. But I think that yes.
I'm sorry to interrupt. Was the question whether the proceedings were likely to involve a substantial dispute of fact agitated before the judge?
Well, you remember, Justice French, that this was these applications were heard on the papers. The best I can do is to refer you to our own submission in response to the applications. And that is at page 665 of the bundle. And I think within that, there is a submission. I can find it. 665. Yes, 665. I think, so I just find the reference. On the page 669, this was our submission in response, and you'll see that these were taken into account by Justice Sawalehi in his judgment, where we, first of all, at paragraph 26, indicate that the applications appear to be unsupported by evidence, and secondly, that they had expressly, at paragraph 27, that there had been an express deferral in terms to the court's discretion, and that was consistent with the course adopted by the court, namely to hold a hearing. And that is also reflected in Justice Sawalehi's judgment. And then at paragraph 20...
I'm sorry, that was not a concession. There was no concession by the defendant that the matter was a Part 8, as I understand, by reading the... it's a statement of the obvious in a sense, that the court has the power under 8.4 to decide this should go on as a Part 7.
Oh, yeah.
I suppose there's nothing in the judgment itself, is there, that addresses the substantive question of whether there is likely to be a substantive dispute of fact or substantial dispute of fact?
Yes, and nor did, you'll see from the submissions of my client that we did not engage on that issue, the applications, because those issues were going to be determined. Those issues are going to be determined in the Part 8 hearing when it occurs, and at that point we believe the Part 8 hearing would be reconvened.
Wasn't that pretty apparent from the defence that had been filed back in April?
Yes, of course. The defence says that the discretion of the is being deferred to, and of course we understood that the Part 7, Part 8 proceeding issue was clearly on foot. Nobody is contending otherwise.
Sorry, the question is, the fact that there was likely to be a substantial dispute of fact, was that not apparent from the defence which was filed? Forget about the preparatory or opening statements.
With respect, Justice Frenchy, that issue, my client's position on that is that there is a good case, we say a strong case to be made for the continuation of our Part 8 application as a Part 8 proceeding, given the confines of what we seek to do. And that is a matter that has not yet been argued below. But we do obviously have to tackle that issue in terms of the matters that we say are extrinsic, effectively, external to the issue of law that arises. And that we wish to have that issue adjudicated below. It has not yet been.
Almost converge upon a proposition that you were entitled to something like, you were to say that you were to be entitled to something like summary judgment on the facts of your statement of claim, because there's no dispute on this.
No. That is not the parameter, that is not the perspective of that argument. The argument we have is that when one takes the pleadings on our case in these proceedings and sees what we are seeking to enforce a contractual provision, that is something which on the issues is capable of being determined, notwithstanding the wider disputes of fact that are there. And that is an issue that Justice Cook may, when these matters come back before him at first instance, at a case management level, may wish the parties to address him on. There's a very strong hint in the final paragraph of his judgment, I think it's paragraph 38, that he wants the Court of Appeal to give its deliberations, obviously, on these applications. But when the matter comes back before him, the case management of the two proceedings together, one being a Part 7, the other being a Part 8, will be a matter for him. And that is, in my respectful submission, the correct way that this should go, given the function of this Court of Appeal. And
these aren't
we also, yes,
things, are they? That's different sort of case management lines. Part 8 takes you along a kind of a fast track, I suppose. Part 7 takes you along the more conventional track, including disclosure and all the rest of it.
Yes, indeed. Remember that we brought these proceedings, what we believe to be a pretty straightforward case for the enforcement of a clear contractual obligation which was being repudiated and refused to be performed. Now, there are two sets of proceedings. The issue, the legal issue, which is fundamental to this hearing, is to these proceedings, 024, are the issues of public policy. They have been fully pleaded in the pleadings, and they will be adjudicated in due course. It's our case that issue, notwithstanding that it is a very interesting one and would call for some very interesting legal arguments, is nonetheless one that is appropriate for determination by the Part 8 procedure, and that it's not going to be assisted by disclosure. Now, that may be that Justice Cook at the end of the day disagrees with us, but it's not the function of this court to step into that and direct the matter from here when it has not been adjudicated upon, has not been subject of real submissions by the parties. You can see the extent to which on these applications, as case management decisions in the narrow sense, we made arguments that we believed were sufficient to dispose of these applications, which came out of the blue and hijacked the procedure which was in train. And the judge below agreed with us on that. And he agreed with us because when one looks at the arguments that are made about whether the appellant was in fact guilty of delay, none of them stand up. And it is quite clear that the judge assessed. You may have a different view. You may wish to say, well, that's not really fair. I think I might have taken a different view. Members of the court may think, well, we would have been more tolerant. But that's not your function. The judge below has assessed that situation, starting from the beginning of his judgment, where he sets out at the very beginning, at paragraphs 2 and 3, the role of the court in its case management function in relation to Part 8 procedure. He specifically draws attention to the special character of Part 8 proceedings, and he sets out the general rules under RDC 823 that an application ought to be made as soon as it becomes apparent to the applicant that it is something to be done. And that means as soon as, refers to that as translating to immediately. And he then goes on to say that in this particular case, through a careful analysis of what in fact happened, he identifies when specifically the appellant was on his assessment first in a position to make the applications that she identifies. And the judge identifies the counterclaim application as one which he says ought to have been made, ought to have been apparent immediately upon the receipt of the pleadings or particulars of claim. He identifies the transfer application again as one that has been made early, and the evidence application equally. So he carefully identifies one of them. He says arises at the point of defense. I'll just remember that in a minute. But this is impeccable reasoning in terms of what the judge below has done. He's spent careful analysis of exactly what happened. And he also looks at the reasons and the causes of delay. He identifies them, and then he says, well, actually, these causes of delay were individually known to the appellant before these events, and he goes back to say that when they would have been apparent, and says that therefore there was not respect for the ruling 8.23, and that's a matter in his discretion that he validly took into account, that there had been a breach of that requirement under Rule 8.23. 23.8, excuse me, 23.8 is the other one. So when one is faced with these appeals, in my respectful submission, it would be unfair, and in my respectful submission, contrary to the appellate of this court, to now say, having in circumstances where the appellant actually deferred to the discretion of the court and was participated, as the learned judge below highlighted, not only did they not raise the objection with the Acknowledgment of Service, not only did they expressly defer to the discretion in 8.4 when filing their defence, parties then conducted themselves. My client was happy that that Part 7, Part issue was on foot. So was the court. Everybody knew that Part 7, Part 8 issue was on foot. And we were heading for a hearing. And it is just it is a topsy-turvy type of submission on behalf of Mr. Iqbal to suggest that his client had no choice because the court hadn't exercised a discretion 5 days before the hearing bundles were due to be filed. That is not, as a proposition of law, it's clearly incorrect. The judges of the Court of First Instance do not have an obligation to rule under 8.4. It's a discretionary matter. And in this particular case, as I've said, the Justice Al-Sawalehi, no doubt, was waiting until the hearing bundle had been filed before he read all the material. Of course, even if he had read all the material as it came in, if he was swatting up in advance, and there's no evidence to say that he had, there's no evidence to suggest that he declined to exercise the jurisdiction, still less that he exercised it improperly. There's simply that attack by Mr. Iqbal on paragraph 33 of the judgment cannot be sustained. Mr. Iqbal referred to Rule 8.17 and 8.18 as supporting his case, but it's to the contrary. 8.17 provides that you must provide an objection on the Acknowledgment of Service, and then it goes on to say that the court, when such an objection is made, will give directions as to what it appears appropriate. But in the absence of an objection, of an objection made under 8.17, of course, no directions are required under 8.18. And so, therefore, that entire submission is incorrect. And Mr. Iqbal says that they waited until he said, when we saw no hope that the court was going to give the direction under RDC 8.4, that was the moment they decided to make some clarification. And again, that is that proposition is based on the notion that in some way the court had deviated from its duty, when of course it had done nothing of it. And in furthermore, in circumstances that the very issue which Mr. Iqbal describes as his flagship point, the question of whether these proceedings ought to be transferred to Part 7 or Part 8, when that was actually still on foot, everybody proceeding on that basis, and everybody preparing for the hearing with his client's active participation and encouragement, to then say, well, we then had to have that issue predetermined by an application without a hearing. That's the logic of their position. Position is actually it's fairer for the court in advance of a hearing where we were going to actually hear counsel on both sides on these issues by reference to the evidence. That in advance of that, we should torpedo that hearing and the judge should take a view on the papers of that and short circuit that hearing. The judge decided not to do that. And in fairness, our position and the procedure which is now being followed, or sorry, not our position, but the procedure which is now continuing at first instance is one which is consistent with fair procedure and consistent with the rules. And it's one which has been eminently within the discretion of the judge below.
Okay, thank you. Is there anything else you want to say, Mr. Dillon?
Yes, I do want to say a few more things, Chief Justice. I'm not sure whether Mr. Iqbal has finished his submissions.
No, this is just on this issue, issue of service, acknowledgement, and notice to contest or notice to apply to move to Part 7. Only on that first.
I think I would like to supplement what I just said at the risk of bringing the court to, I will do it speedily, but there are some key passages in authority that I do wish to rely upon in terms to reinforce the points I've
Please do.
But I'll
yes, please do.
Do you want me to do that
please
now?
Continue.
This is the legal argument, and I'll try and be brief. I'm conscious that I may be cutting across Mr. Iqbal now.
Never mind, don't worry about that. Can you finish whatever you want to say on the legal aspect, and then we'll ask Mr. Iqbal if he has anything to say.
With the court's permission, and this may take about 15 minutes, but I'll really try to be as quick as possible. It is something which I possibly intended to address you on later.
Yes, the judges in Sydney, there are 7 p.m. You can go a bit more while, then we can stop for them to have their dinner.
So far as I'm concerned,
okay, yes.
But Mr. Dillon Malone, it would help if you would just state in one sentence what is the legal proposition that you are intending to support.
Yes, indeed. Well, they're interrelated, but they're all related to the jurisdiction of this court and the approach of this court as a court of appeal. And they are references to the leading DIFC judgments and the leading English judgments upon which we rely. And they are some.
Answering my question. What is the legal proposition that you want to support?
Well,
is it that the Court of Appeal should never interfere, or what is it?
There's a sequence, Justice Giles. I'll do my best. There's a sequence of propositions. Obviously, we say that these are case management decisions, and that on the established precedent of this court, there is a generous ambit within which reasonable disagreement is possible as matters of case management, discretionary matters within the remit of the court below. And it's established that there's a heavy burden in that regard. And I can refer you in that regard to pages 931 and 932. That's the judgment of Justice Field in the Karafi Court of Appeal judgment of the 22nd of March 2018. In addition, I rely on the further Karafi judgment of Justice Cook in the Court of Appeal, which included Justice Salalehi, at page 935. And you'll see on that page, there's a description of the approach of the appeal court in relation to discretionary matters falling within the purview of the court below.
Well, ultimately, Mr. Dylan Malone, the proposition is that, is it not, that the Court of Appeal does not have a substitutive role when it comes to discretion. We have to be satisfied that the discretion is carried in some way, and that's not satisfied by the fact that we might have made a different decision if we'd been sitting in the judge's seat at first instance.
Yes.
And the usual relevant factors, irrelevant factors, all those sorts of things, procedural fairness, etc., would apply. I think that's sort of holy writ around the common law world anyway. So,
and I know, Justice French, from reading around some of the Australian materials, that in an administrative law context you considered some of the. But I do say yes, indeed, that is exactly correct. And the judgment of Lord Justice Lewison in Abdullah and the Commissioner of Police for Metropolis, I just maybe open that, it's at page 1089. And this is quite a recent judgment of Lord Justice Lewison for the Court of Appeal. It related to striking out of pleadings. It was a case management matter. And the point in this case was that it was clear that there was a fine balance, a fine judgment had been made by the judge below. And you'll see from the headnote on page 1089, the Court of Appeal will not likely interfere with the case management decision and will support robust and fair decisions by first instance judges. Where the balance is a fine one, an appellate court should respect the balance struck by the first instance judge. And then it goes on to say satellite appeals should be avoided if parties understand the approach. And I refer you then, it's a short judgment, and I refer you to the last page of it, at page 1095 of the bundle. You'll see.
Before you proceed on, Mr. Malone, you are saying that this is a case management decision. Maybe I'm just repeating what Mr. Justice Robert Friend just mentioned to you. You are saying this is a case management decision. Why do you say so?
And yes, within the meaning of the rules and within the meaning of the case law of this court. If I refer you to paragraph 25, you'll see there's a reference to the submissions.
Yes, 1095.
Rather, his submissions were directed to the weight that the judge attributed to the various factors that he did take into exercise of his discretion. And that is not a promising start to an attack on an exercise of discretion. What it amounts to is a submission that the judge's decision was perverse. And I say in this case that when one looks at the heart of what this appellant is arguing, it is simply an attack on the judge's assessment of the evidence. That's what it is. It is, and as Lord Justice Lewison said, that's not a promising start for an appeal against the exercise of a discretionary decision. And in paragraph 28, he says, in my judgment, the same approach to decisions by first instance judges to strike out claims is in a case in which, as the judge himself said, the balance was a fine one, and appeal court should respect the balance struck by the first instance judge. As I have said, I would have found that the balance tipped the other way, but that is precisely because in cases where the balance is a fine one, reasonable people can disagree. It's impossible to characterize the judge's decision as perverse. In the Chartwell case, Lord Justice Davies also said that if parties understand the approach that this court will take to discretionary interlocutory decisions of first instance judges, then satellite appeals should be avoided. I echo that. It is a depressing fact that this satellite appeal has added a further year to the overall delay in bringing this claim to trial. And I say those words ring true here also. These appeals, are appeals against case management decisions, which for good reasons are a heavy burden lies on an appellant seeking to overturn them, because it's precisely the policy of the Court of Appeal in the exercise of its appellate function to maintain case management decisions at the first instance, because appeals also, unfortunately, on these issues obviously do very much upset the timetable and the fairness that goes along with adherence to an orderly timetable in proceedings. It was the assessment of the judge below that upsetting of the procedural timetable ought not to be allowed, and that the process that was on foot should continue. And in my respectful submission, that was not a perverse decision. And this court should similarly lament that this appeal came before it. It's actually very unclear what grounds of appeal are properly before the court. As the court will have seen, permission was granted by reference to the existence of a compelling reason. And if I might just address you briefly on that compelling reason aspect. I don't know whether the court wishes to say something about it in its ruling, but it does seem to me to us that we are all at a disadvantage, and that it's procedurally odd that and difficult to be before this court by reference to a supposed compelling ground which has not been identified. And if I could just briefly address you on that. Mr. Iqbal has put forward quite ingeniously and creatively 2 points of potential compelling reasons. One relates to the absence of a possibility to tick the box on the form, which obviously it falls away. And the other relates to whether or not the trial judge, whether or not a judge has a discretion, whether or not a party has an obligation to object to Part 8 proceedings in terms at any stage. And the second proposition is uncontroversial. In fact, it's mundane and banal. It's clearly the case that there is no such obligation. I don't think that the issue, in any event, approaches the level of normative importance or of general importance that would fall within the category of compelling cases within the meaning of the rules or of the case law of this court. The second argument is the argument that we've identified, and I have to say we ventured this sort of in the spirit of things, to be good sports really, because it is our primary submission that there is of course no compelling reason for why this court has this appeal before it. We thought that maybe some of the things that Ms. Justice Al-Sawalehi had said below in relation to the streamlined character of Part 8 proceedings might be something that this court might wish to express a view on or take into account and elucidate. But the judge said it below, and if you reiterate it above, all the better. But it's hardly, in our respectful submission, again, something which calls for which falls within that category. The third issue, and I suspect personally that this may be the one which was in the mind of the judge below, is that underlying the proceedings is an issue of public policy concerning the validity and enforceability of nominee arrangements in commercial companies in onshore UAE law. And the judge may have thought, well, these applications have all been dismissed by me. That may impact the hearing of those issues, and therefore that's a matter of public importance. Now, we respectfully disagree if that were the case. Of course, we don't know, because first of all, the applications, the subject of this appeal, of course, do not raise any issue under that argument. As I've stressed, that argument has been fully pleaded in the underlying pleadings and will be fully addressed by the court, by the court below, and possibly by this court on appeal in the substantive proceedings. But the idea that these case management decisions, insofar as they could potentially impact, raises an issue of public importance, I think is incorrect. And I think that in that regard, I refer again to the reality that no issue, nobody was deprived by these rulings of an adjudication on the evidence or of any argument they wish to put forward in relation to the validity of the agreement. That issue is fully joined, would be heard in the first instance, in the first hearing of the Part 8 procedure, if at that stage the court believed that it required factual context and required to adjudicate upon required disclosure and required to adjudicate upon conflicts of fact, then the court, that is a matter for the court below. And again, when one looks at Judge Cook's judgment below, you'll see running through it perhaps a hint that he perhaps will take some convincing by our side on that issue. But nonetheless, it is an issue which has yet to be argued below, and it's not a matter for this court. And it's on no stretch in our submission could it be said that there is a compelling reason for these appeals. I do want to say just one, without, if this is going to be my last submission on the law, I do wish to say, because there have been some references by Mr. Iqbal in his submissions to the overriding objective. One takes the judgment of the Court of Appeal in the case of Dylan with an H, D-H-I-L-L-N, and Asiadu, which is at page 1078 of the, and if you look at paragraphs 30 to 33 of the judgment of Judge Barron, at page 1084 to 1085, you'll see very much that the overriding objective underpins precisely the rules upon which we have been relying. It underpins the case management case law, that it is part and very much supported by the overriding objective, that the discretion of judges at first instance in relation to case management decisions ought to be respected. I'm just taking one last look at my notes, Chief Justice.
Sure.
I'm sorry, I have separate notebooks and I've lost my page. Here we go. And you'll see a reiteration of the satellite litigation avoidance in paragraph 47 of the judgment of Lady Justice Arden in RSA against TNN. The judgment is at page 1018 and paragraph 47 is at 1036. And there's one last judgment I just want to briefly open. It's at page 1073. And it's the Tanfern judgment, perhaps the court will be familiar with. It's the judgment of Lord Justice Brooke from around 2000. Judgment starts at page 1067. And the paragraph is at paragraph 32 on page 1073. And this is the established, well-known dictum from the House of Lords in G&G, which was cited with approval by Lord Justice Brooke in Tanfern. And if I could quote the inner quote at E, capital E, certainly it would not be useful to inquire whether different shades of meaning are intended to be conveyed by words such as blatant error, words such as clearly wrong, plainly wrong, or simply wrong used by judges in other cases. All these various expressions were used in order to emphasize the point that the appellate court could only interfere when they considered that the judge of first instance has not merely preferred an imperfect solution, which is different from an alternative imperfect solution which the Court of Appeal might or would have adopted, but has exceeded the generous ambit within which a reasonable disagreement is possible. And then Lord Justice Brooke, so far as the second ground for interference is concerned, it must be noted that the Appeal Court only has the power to interfere if the procedural or other irregularity which it has detected in the proceedings in the lower court was a serious one, and that this irregularity caused the decision of the lower court to be an unjust decision. Of course, on this appeal, the unjust argument, as on my understanding, does not arise as a ground of appeal. We're not dealing with an injustice or irrationality. But I think for good measure, we have addressed certain points in our skeleton argument relating to whether the decision below has led to an injustice, and we rely on our skeleton in total. Also, to please have in mind the reasoning of Justice Al-Sawalehi that we have described in a how does one say, a schematic way in our skeleton, which may assist the court.
Okay, is that all?
Thank you, Chief Justice.
Any questions from the other judges? No? Okay, Mr. Gibal, do you have anything to reply?
My Lord, yes, I'm grateful. Now, I believe Judge French raised a very important question about the substantial dispute of fact. Here is this case. Claimants say to the court, please ask the defendant to perform her obligations under 2 contracts because she's a nominee shareholder. That's the claim. The response from the defendant is twofold. Number one, she says, no, I'm not a nominee shareholder. I'm a beneficial shareholder, and I have paid £450,000 dirham. That's one. 2, she says these 2 agreements have been procured on the basis of 1, 2, 3, 4, 5, 6 misrepresentations. That's the defense. The claimant's reply says, well, no, she did not pay £450,000 and we did not make misrepresentations. The obvious question is, isn't there a substantial dispute of fact? There can be only one answer, yes. Let's imagine the position of the judge who would be hearing this Part 8 claim, and these 2 rival contentions are put in front of him. One is saying, she is nominee. She's saying, no, I'm not nominee. I paid 450,000 AED. And then she's also saying, well, I've been subjected to misrepresentations. The claimant say, well, no, you've not been. Clear dispute of fact. Something Judge Al-Sawalehi did not take into account. The question that Judge French raised was a simple, straightforward question, and it took around 40 minutes to my learned friend to give an answer to that, and I regret to say, but with respect, that he did not give an answer because the only answer is detrimental to Mr. Dylan Malone's case. That's number one. Second submission, delay. In these courts, day in and day out, we see delayed applications. Making a delayed application seeking permission to appeal is not uncommon, or making other applications delayed are not uncommon. So once an application is made with delay, well, number one, in these rules, there is no specific time limit by when an application for transfer or application for counterclaim or application for additional evidence must be made. There is no such deadline. Now, let's suppose if there is a case which has the deadline, for example, 21 days or 14 days, whatever. So in that situation, the judge who is dealing with the application has to consider at least 3 things. Number one, how significant is the delay? Like how many days or months or years out of time? Number two, the judge has to look at the justification or reasons for the delay. And number three, the judge has to see the prejudice. Which party is likely to suffer more prejudice? And in determining this third question, the merits of the application must come into play. Now, for example, if I bring an application for permission to appeal 30 days out of time, and the court thinks 30 days is a long period, justification is not good, but the application for permission to appeal is strongly meritorious. So in that situation, it's a judgment for the court to make a balanced judgment taking into account these 3 factors. when it came to Judge Al-Swalehi, he only took into consideration the delay. He did not say how long the delay was. He did not say, well, he did say the justification for the delay. The justification is in the judge's hands. I refrain from criticizing that for a moment. However, the third important factor, prejudice/merits, the learned judge did not go anywhere near that important question. That is why the references to number of authorities by my learned friend, in which he was at pains to make a point, particularly referring to Judge Lewison, he says that the judge's assessment of evidence, well, that's irrelevant to this case, because in this case, Judge Al-Swalehi did not assess the evidence. Furthermore, my learned friend made reference to other cases in which he was again at pains to make a point that the judgment of the judge was fine on balance. In this case, there is no question about fine judgment or otherwise, because the learned judge did not consider the merits. So the question of whether the judgment was fine or otherwise again falls away. My learned friend also refers to Judge Cook's judgment. That is not in the bundle before this court, and I am therefore reluctant to address any judgment made by Judge Cook at this particular point in time, albeit it's irrelevant for the questions before this bench at the moment. Lastly, if I could, with respect, make a reference to my skeleton argument's very last page, well, in fact, the second last page, I should say, is paragraph number 84. And in that, paragraph 84, my lords, with all of my youth, inexperience, or lack of studies or experience or research, I have attempted to bring forth 2 points of compassionate or compelling reasons. And the second reason that I put forward is, little b on the last page, the current version of Form AOS, Form P8/02, is not adequate to meet the requirements of 8.17. That's quite a straightforward and a bold submission. Now, I completed my skeleton arguments on 27th of December. 28th of December was the date when the appeal bundle was to be filed. My learned friend's aides in his firm were consulted throughout about the preparation of this bundle. This skeleton had been disclosed to them, and they did not refer to P8/02 form. And indeed, this morning, well, when I say this morning, that's according to the Dubai and London time. As per the Dubai time, it was 9:28 in the morning when I received an email from a colleague of Mr. Dylan Malone, and he sent me the copy of the form P8/08, and he asked my instructing solicitors to add that form to the appeal bundle, page 888A to 888C. And in that particular form, there is no mention or there is no provision to make an objection on the suitability of Part 8 form. That is in the bundle and came to me at 9:30 this morning and added to the court bundle shortly before the hearing. It was then now half an hour or maybe 1 hour into this appeal hearing when Mr. Dylan Malone, he came up, and I would say with a bombshell on my argument that the court form P8/02 does include that very provision. So the question is, if this was such a straightforward point, why did it take Mr. Dylan Malone around an hour into the appeal hearing to bring this before the court and putting me in a position where I cannot give a reply to that because it obviously needs to be investigated? So I would.
Mr. Iqbal, wasn't this argued at the before Justice Swelly?
I wasn't, my lord. No, I was not. The hearing, the hearing before Judge As-Swalehi was on papers.
Ah, I see. Yes, of course. I forgot that. Sorry, I forgot that.
That's all right, my lord. So these are all the rebuttals to the submissions made by my learned friend. Now, I understand that, and I have very well grappled from the fact that all the members of this bench have understood the facts of this particular case and have grappled with all the papers that appear in the voluminous bundle. So I'm not going to go into every single page. However, the points that I have made in my skeleton arguments, I am reluctant to repeat them because I understand that brevity is virtue and repetition won't take me anywhere. However, I appreciate that before reaching the decision, this bench will take into consideration all the arguments that I have put in my skeleton arguments, and the fact that if I do not repeat them here or say them loud, perhaps, or maybe to the disappointment of those instructing me who may be listening to me, nevertheless, I would leave it into the court's hand and believe that my arguments will all be taken into consideration, unless I can give any further assistance to the court. I bear in mind that it must be more than 8 o'clock per Sydney time.
Are you from London, Mr. Iqbal?
I am based in London, my lord, yes.
So is Mr. Dylan Malone from England, from London as well?
I beg your pardon, my lord?
Where are you from? Where are you speaking from? London?
My lord, I am based in London, yes.
Yeah, you're speaking from London now.
That is right, yes.
Okay, good. Thank you. So, any question from the judges? No? Shall we take a break and we'll come back? I think we need a long break. Say 45 minutes? 45 minutes?
I'm grateful, my lord. Just for the sake of completeness, so that everybody remains on one page, let's determine the Dubai time that we should be back in.
The Dubai time would be 1:15, is it? Now it's 12:30. 1:15, 1:30. I want to give the judges in Sydney a chance to have their dinner.
Okay.
Why don't we make it a shorter time and delay dinner?
I just have 2 points to make in rebuttal, if I may. They'll be very quick. The first point is that there are 3 judgments of Justice Cook in the bundle. One, and the page numbers I'd refer the court to respectfully, and they were all very, very useful and on point on this specific issue of case management. One is the one I've referred to at page 935, that's in the first Karafi judgment. The second is Standard Chartered Bank against IGPL. You'll see page 957 of that judgment. And the third judgment is his judgment in Veggie Bar at page 981 to 982, paragraph 6 to 7. Those 3 judgments reinforce the high status of this principle as adopted by this court in its consistent case law. And the second point I wish to make is that the accusation, I suppose, that I deliberately hijacked Mr. Iqbal is of course not the case. I had a conversation with him this morning and explained to him that we had uploaded the form. It was my belief at the time, because I have a physical copy of the one which has the drop down in it when you tick part 8. It was my belief that that document also included the other one. And the reason for the delay was quite simple. Mr. Iqbal himself put in the English form just a couple of days ago. And it was in response to that that we asked those instructing him what the purpose of that form was. We were not given an explanation, but then of course I divined from the skeleton that this was the purpose of it, and we put in the correct form. And the suggestion that we should be to blame for the failure of
it's not an important issue, Mr.
I know.
It's not very important.
But okay, but on the part of my
sort of
time,
allegation, cross-county allegation all the time. So don't forget about it. It's not important.
exactly. I am very
It was an information, Mr. Dylan Malone. If it took you so long to find it, is it any surprise that he hadn't found it? That was the sort of argument I thought he was running.
Well, I think that the answer to that is that we have, as a firm, made many Part 8 applications, and so have many others. In which the box appears and you tick it and you represent your position. That was not done, and the suggestion that we should be in some way to blame for failing to read the mind of the appellant and the appellant's legal team ought to be put in context.
Okay, Mr. Malone and Mr. Iqbal, although I said 45 minutes, but you're always on standby, so we can call you anytime before that if you're ready to come back to you. Is that all right with you? Yeah, good. Thank you very much. So we'll, judges, we are getting out of the screen and we'll go back to the other one for discussion, the earlier screen.
Thank you very much, Chief Justice. Thank you.
Thank you, my lord.
Thank you.